I recently introduced a sense of the Senate resolution urging the Supreme Court to permit live television coverage of their proceedings. And I did that because I think that the American people know relatively little about the Supreme Court, and it is important that there be transparency and a public understanding as to what the court does because of their very, very important role in our lives. The Supreme Court has the final word. The President may act, Congress may legislate, but the Supreme Court has the authority to nullify what we do on grounds that our action is unconstitutional. But when the court decides so many of the very vital questions, who will live, who will die under the death penalty, a woman's right to choose, civil rights, executive power, congressional power, I think the people ought to have a better understanding of it. And I think the transparency would enable people to understand and express themselves and have some influence on what the Supreme Court does. And let me give you a couple of illustrations. The Supreme Court, in effect, decided the 2000 election between President Bush and then Vice President Gore. A 5-4 decision, really very much a political decision. The decision was made not to count all of the votes in Florida because, as Justice Scalia put it, there would be irreparable harm to the Bush administration by challenging the legitimacy of the government. Well, it's a complex subject which can't be explained on a soundbite, but on that day, the television trucks surrounded the Supreme Court, but they weren't permitted to go in, talking to people on the steps. And the American people, I think, had a right to know what was going on inside the chamber to evaluate what was happening. Then we have the most fundamental clash, perhaps in history, between the Congress legislating the Foreign Intelligence Surveillance Act on the exclusive ways to get a wiretap, contrasted with President Bush's warrantless wiretap program, which he asserts under Article 2 powers as Commander-in-Chief. Well, that's a tough question. It's a balancing matter, but the court declined to hear it. And I think the court should have heard that case. And the American people have very little knowledge as to what is not going on as well as to what is going on. There are what we call circuit splits. There are 12 courts of appeals for different circuits, geographically divided in the United States. And sometimes you have the Third Circuit, Philadelphia, for example, the Ninth Circuit, San Francisco, for example, deciding different ways. And district judges in Wichita, Kansas, don't know which way to go. And the Supreme Court declines to hear many of the circuit splits, which have very, very important legal principles. And as I outlined in an extensive floor statement, which I'd be glad to send to anybody who'd like to see it, the court is not too busy to undertake more work. They did more than 400 cases a year, opinions, a century ago. A decade ago, they did about 150 opinions. Now they're down to less than 70. So that these are things which are not known unless you study them on the Judiciary Committee, as I have. But this is a matter that I have been pushing for a long time, and I think it'd be very helpful if people knew what the Supreme Court was doing, because that could, through transparency, have an effect on accountability for the court. They're the final word, but we ought to know what they're doing. Just like the House of Representatives is televised and the United States Senate is televised, today we get most of our information from television. So let's urge the Supreme Court to open up their doors to live television as well.